The history of Peru in the 20th century is a history of drama and tumultuous change. Victor Raúl Haya de la Torre was involved from his early days as a student leader in the 1920s to becoming president of Peru's Constituent Assembly just before his death. In 1948, he was involved as one of the leaders of a coup attempt which quickly failed. He sought asylum in the Colombian embassy in the Peruvian capital, Lima. Colombia granted asylum, then negotiated with Peru for him to receive safe passage out of Peru. Peru refused, and Colombia took the matter to the International Court of Justice. One argument made by Colombia was that there was a customary international practice among American states of respecting asylum decisions of this type, and this practice had reached a point where the court should treat it as legally binding. This allowed the court to make important statements about customary international law. Customary international law is important because before the days of large multilateral treaties, international law often simply emerged from the common practice of nations towards one another. This practice or custom is one of the foundation sources of international law. In this case, the court set out the rule which would apply to determine whether a custom has become customary law. It described customary law as constant and uniform usage accepted by law. The second aspect of customary law which the court had to consider was whether customary law had to be universal among all nations or whether there could be such a thing as regional customary law reflecting the common practice, say, of Central American countries. The court found that regional customary international law was possible. It did so in the course of setting out Colombia's burden of proof. The court said, the party which relies on a custom must prove that this custom has become binding on the other party. The Colombian government must prove that the rule invoked by it is in accordance with a constant and uniform usage practiced by the states in question, and that this usage is the expression of a right appertaining to the state. From this case, we learn that customary law requires constant and uniform usage accepted by law, and that customary law can occur at a regional level. It need only be binding on the other party, not on all the nations of the world.